Welcome back to Winning Isn't Easy. The David versus Goliath story of Miss Outward, an electrical engineer with POTS. Postural orthostatic hypotension, POTS claims, can be difficult to prove because disability carriers insist on objective evidence of both the diagnosis and the restrictions and limitations assigned by your physician. And disability carriers play games in these cases. Let's talk about how these games are played out. And I'll give you an example. Mrs. Outward was an electrical engineer, and she worked for a company by the name of Eaton. She was a strategic pricing manager, and she did work also as a sales marketing trainer manager, and she was a corporate marketing manager. Unfortunately, after suffering a miscarriage, her physical condition began to deteriorate. She was diagnosed with a number of medical conditions, including Epstein-Barr virus and POTS. Her disability plan, and you need to get out yours, provided that she would be entitled to benefits for the first 24 months if she was totally and continuously unable to perform the essential duties of her regular occupation. And after that, she would be entitled to benefits only if she was totally and continuously unable to engage in any occupation or perform any work for compensation or profit. Now, of course, you need to look at your policy to understand the definitions of disability. But her plan had a trap, and that trap was used to deny her claim. The plan required that she provide objective findings to substantiate the period of time that her health care practitioner indicated she was disabled. All right, so what did objective findings mean? Well, you had to look in her policy, much like you have to look in your policy. Objective findings were defined to mean findings that can be observed by your healthcare practitioner through objective means, not just from your description of your symptoms. The policy said that objective findings could include physical examination findings that document functional impairments or capacity, diagnostic studies or imaging studies, a diagnosis, X-ray results, observations of abnormalities on examinations, and they wanted objective evidence of medications or a treatment plan. So in this case, Outward's physicians agreed with a diagnosis of POTS. They noted that during periods of the orthostatic stress, she would pool a greater than normal degree of blood that would result in an increase in her heart rate and her myocardial contractibility. As a result, she had extreme fatigue, exercise intolerance, and orthostatic intolerance. Many of the symptoms she complained of, fatigue, pain, numbness, instability, cognitive issues, and exercise intolerance, are not necessarily demonstratable through medical testing. But her doctors listed a number of verifiable medical findings supporting the diagnosis, including blood pressure readings, hemodynamic testing, and Cuisart findings. Now, the plan administrator said, "Nah," and rejected those findings and requested a transferable skills analysis by their vocational evaluator. And of course, they said to their vocational evaluator, "Don't consider the opinions of the treating physician. Rather, we want you to consider what transferable skills you think she has based on our liar for hire doctor's peer review analysis of her restrictions and limitations." Well, what were those? The liar for hire doctor peer review said that she could do a light physical job for at least 4 hours a day and as long as 8 hours a day. And as a result of those inaccurate and wrong restrictions and limitations, the vocational evaluator did the transferable skills analysis and determined that she could be a call center service representative. Well, she didn't even have that kind of experience, but nonetheless, the disability carrier denied her claim. On appeal, her treating physician explained why the medical reports and a functional capacity evaluation that the plan administrator was relying on were incomplete and incorrect. In other words, her treating physician had to take apart the disability carrier's physician's wrong conclusions. Her treating physician said, "Look, you didn't address the unscheduled breaks she has to take every 5 to 10 minutes during an 8-hour day, and she needs a rest period of every 30 to 60 minutes. That's unfortunately not uncommon." And the disability carrier said, "Too bad, so sad. We are going to uphold this denial." Now, Miss Outward didn't give up. She filed a lawsuit. This ended up in the Sixth Circuit in a case called Outward versus Eaton Corporation Disability Plan. And the Sixth Circuit found that the denial of the claim was what's called arbitrary and capricious and remanded it back to the plan for a full and fair review. So what did the Sixth Circuit say? They said, look, you didn't consider all the relevant medical evidence. You used three unqualified doctors to evaluate the claim. And you didn't get an expert to address Ms. Outward's issues. The court also took the plan to task for noting that while the plan required her to provide objective findings of disability, the plan purposely ignored the test results, which were positive. The court said, look, relying on test results is appropriate, but you have to also consider the totality of the circumstances. You've got to look at the diagnosis. You've got to look at the symptoms. You've got to look at the prescriptions that she was given. You have to look at the treatment plan, and you have to look at the results of that treatment plan. And the judge said, look, this whole denial was arbitrary and capricious because, one, the treating physician listed all the test results, their observations, their treatment plans, and the prescriptions and treatment that supported the diagnosis of POTS. Two, those facts should have been considered by the plan administrator along with the quantitative testing to evaluate the extent to which she was disabled. Now, because the opinions of her treating physicians were based on the test results, treatments, and observations made over the course of many years, the court said, look, I think that your reliance on the opinions of doctors who merely reviewed the records or who only maybe saw her once was arbitrary and capricious. You've got to consider everything, and you can't willy-nilly reject things. Number three, the plan cannot cherry pick medical evidence, which is exactly what they did. Number four, the court said, look, your denial is basically predicated on an independent, in quotes, review of the medical records. And while those physicians who weren't qualified recognized that she exhibited the multiple symptoms normally seen in a POTS case, that they couldn't also ignore the symptoms that are commonly recognized in POTS. So she had extreme fatigue. Now we know that generally can't be verified by objective medical testing, nor could her complaints of dizziness and fatigue. But the court said, look, you just can't conclude that there are no restrictions and limitations just because there's no objective testing that will measure her fatigue, her dizziness, or her other symptoms, which are recognized symptoms of fatigue. You have to, you just can't rely on objective findings to the exclusion of other applicable objective findings in determining the eligibility for benefits. In other words, you've got to look at the totality of the POTS symptoms that she presented with. Were they consistent with the diagnosis? Yes. Were they consistent with the kinds of symptoms that other people exhibit that cause restrictions and limitations? Yes. Are these tests, are there tests to verify the extent or nature of these complaints? No, but you just can't ignore them because there's no objective testing. You have to consider them in the totality of the claim. And so fifth, the court said the carrier's blind reliance on the results of certain medical testing basically skewed their analysis, not only their medical analysis, but ultimately their vocational analysis. And the court threw out their conclusion that she was not entitled to her disability benefits. And so I think that is a phenomenal decision, and one that illustrates the problems that you will see in POTS cases. Now, I'm going to finish up this episode by talking about the subjective medical evidence defense, which also can be a case killer. We'll come back in a minute.